Well, today has been dubbed American Censorship Day. An incredible amount of opposition is mounted towards legislation working its way through both the House and the Senate to combat copyright infringement on the web. Now, we've spoken about the Protect IP Act many times on the show, but today, the House Judiciary Committee held a hearing on their version of the bill, known as SOPA, the Stop Online Privacy Act. Now, the Protect IP Act would allow the Attorney General to create a blacklist of websites that they see as engaging in infringing activities to be blocked by ISP providers, search engines, payment providers, and advertising networks, all without a court hearing or a trial. But SOPA goes even further. And numerous groups have come out against both pieces of legislation, from civil liberties and free speech groups like the ACLU, the Electronic Frontier Foundation, various think tanks, a bipartisan group of lawmakers, including Ron Paul, more than 100 legal scholars, and even tech giants. Take a look at this full-page ad taken out in the New York Times today. It was taken out by AOL, eBay, Facebook, Google, LinkedIn, Mozilla, Twitter, Yahoo, and Zynga. So much opposition. Might Congress actually listen? Here to discuss it with me is Alexander Howard, the Government 2.0 Washington correspondent for O'Reilly Media. Alexander, thanks so much for being here tonight.
Nice to be here.
Okay, so like I said, our viewers are very familiar with the Protect IP Act. But let's talk about what the differences are between Protect IP and SOPA, why this one is considered to be so much worse.
Well, I think one of the ways that people tend to look specifically at is this private right of actor, and you refer to that a little bit, which is to say that someone who has the ownership to a given piece of content and feels it's infringing could then go right to the Department of Justice and do that in a way that's not necessarily public, and then make a complaint against it. And then it would give the Department of Justice certain powers to then take that site offline. And you talked about a number of them, right? The idea that you could take it out of search results, the way you could constrain it financially, and then potentially the most controversial, which is using the domain name system to make it so that when people search for the domain of the site, they simply couldn't find it.
Okay, but how about the fact, too, that some of these companies, now, if something is posted online that might be infringing on copyright, as soon as they're notified, they just take it down. But won't they be held responsible now? They're going to have to start blocking it, censoring it from the very beginning. They'll face legal repercussions if it ever gets up there? Right.
Well, I mean, the existing infrastructure for this is the DMCA, right? You do a DMCA takedown if you're a company, you see something of yours up on YouTube, for instance, and say, well, we have ownership to that. And you have the individual piece of content that gets taken down. And that's seen some amount of abuse, but it's been a workable system. But it basically says if you see infringing content on a given site, on a given piece, you take that off. What this bill has been introduced around is this idea of rogue websites that are outside of the United States. And Congress, with the urging on of a lot of the people who sponsored the bill and the people who you saw testify today, are interested in finding ways to prevent these rogue websites beyond U.S. jurisdiction from being able to host or link to pirated content. And there are only so many means that you can do that. The one that I think there's broad consensus around is following the money, right? So changing the way that you could fund these sites through advertising or through payment mechanisms. The same thing, in fact, that's been used to strangle WikiLeaks. The one that's quite controversial in the internet community is this idea of using the domain name system to do that.
All right, let's, in fact, talk about the hearing today and who it was that was there. I already mentioned the long list of the tech giants, of organizations out there, of members of Congress that are all opposed to the legislation. But the people that are backing it, you have the Chamber of Commerce, you have the Motion Picture Association, you have a lot of the entertainment industry.
Yep.
How come how come the opposition wasn't allowed to speak or voice their concerns today at this hearing?
You would have to ask Representative Smith and the heads of the
But did they give no explanation?
To my understanding, the Consumer Electronics Association, which is the biggest of its kind, asked to testify and did not have the opportunity. If you took a picture of that table of people that was there, the only one that from the companies you referenced, the biggest internet companies in the world, was Google. And that representative had a pretty tough time today, a lot of tough questioning from the congressman. You didn't see constituencies from the venture capital community. You didn't see constituencies from public advocates, from civil rights organizations, human rights organizations. And notably, you did not see anyone from the engineering side. There was actually a specific point where one of the congressmen raised this issue of whether this bill would be a problem for cybersecurity. And as you know, this is a huge issue in Washington. Cybercrime has been growing as a really important issue. It's important in terms of the national stage, a strategic bit. So when someone brought up this idea that the past counsel of DHS, Lamar Smith was reminded about this. His name is Mr. Baker, that this domain name system security was an issue, something that engineers have been working on for a long time.
We think that's something that members of Congress would care about as well.
They do, and when it was raised, it came up, well, we should know about that. They asked the witnesses about it. It's called DNSSEC, and it's basically trying to build in more security to the domain name system, because without it, there are some ways that your traffic can be spoofed, which can be a significant issue if you're in parts of the world where if your traffic is intercepted, it could be dangerous to you. And essentially, something unusual happened. A group of internet engineers wrote a letter to Congress saying, if you do this, it's going to break what we've been building. Now, I don't know if you've hung out with many engineers. They don't usually like to insert themselves in politics, but they have. So have a number of venture capitalists, including Fred Wilson, including Brad Burnham, and Feld. You know, these guys don't get involved
all around
usually.
it seems rather crazy that the Congress wouldn't at least allow them to come in and have their piece when they're going through, you know, this type of hearing process. And so, what do you think the chances are that some of this might actually go through, either the Senate version or the House version?
Well, it depends who you talk to, right? If you talk to Darrell Issa, who's the chairman on government oversight, he told The Hill today that he doesn't think it's going to get very far. He thinks that the regulatory burden here is going to actually be a significant imposition. The security is one important thing. People actually balk at that, right?
But do you think, really quickly, too, because we're running out of time, I mean, do you think that this also equates us in terms of censorship? We've heard a lot of people say, well, we point fingers at China all the time, and here our government would be setting a very dangerous precedent, you know, for what it looks like around the world.
People perked up when the MPAA talked about that a little bit. There's a very important op-ed written by Rebecca McKinnon in the New York Times today, and she entitled it "The Great Firewall of America," referring to China's censorship mechanism. And this particular principle, this idea that a site should be held liable or not for infringing content that's put onto it, the way we've made the internet over the past 20 years has protected sites from doing it. It's really what has enabled the internet to grow as much as it has. And the principle is intermediary liability, right? That if a site is online, it shouldn't be held liable for user-generated content if someone puts something on there. You know it's going to happen, so what's the mechanism that you choose to deal with it? If you make it so that the whole site goes down, you know, blocked from search results, money gets taken away, DNS goes away, then what is that going to mean for it, and what is it going to mean for the risk tolerance of venture capitalists who want to fund the startups of tomorrow?
Yeah, a lot of people are asking that question. What does it mean for, for entrepreneurs, for startups, for innovation? Well, a lot of people are calling it the end of the internet or the breaking of the internet. Hopefully they will, you know, come to some common sense on this. Alexander, thank you so much for joining us tonight.
Thank you for inviting me.